Hi, this is Josh Blackman. I am the president of the Harlan Institute, and I'm happy to be here for the Harlan Institute ConSource Virtual Supreme Court competition. This year we are focusing on Espinoza versus Montana Department of Revenue. Today we have two teams from Lake Oswego, Oregon. For the petitioners, we have Dalia Liu and Sera Liu. And for the respondents making a repeat performance, we have Michael Murray and Andrea Yang. We are so happy to have you here. Petitioners, you may begin whenever you're ready. You have 15 minutes.
Your Honor, may it please the Court. The question before us today is whether or not it violates the Free Exercise Clause of the First Amendment to invalidate a generally available and religiously neutral student aid program simply because the program affords students the choice of attending religious schools.
In other words, this case concerns whether the First Amendment allows the exclusion of all religious schools from any scholarship program. Under the Free Exercise Clause, as applied in Trinity Lutheran, it does not.
The facts of the case are as follows. Our clients are low-income mothers who for scholarship to keep their children enrolled in Stillwater Christian School. In 2015, the Montana legislature enacted a tax credit scholarship program to benefit those who donate to private, nonprofit scholarship organizations. Shortly after the program was established, the Department of Revenue cited the Blaine Amendment to prohibit scholarship recipients from using their scholarships at religious schools.
When the Department of Revenue's decision was challenged, the lower court agreed with Ms. Espinoza that the program is constitutional. The department then appealed, and the Montana Supreme Court ultimately held that the tax credit program would be unconstitutional in all of its applications. The court determined that because it was the legislature enacting the tax credit program, it would be the wrong entity to provide aid to sectarian schools.
This is incorrect. Invalidating a generally available religiously neutral student aid program simply because the program gives students the choice of attending religious schools is unconstitutional under the Free Exercise Clause. Extending the program to students attending religious schools would not violate the Establishment Clause. For these reasons, the court should reverse the decision by the Montana Supreme Court.
Well, let me interrupt. Counselor, do you see this case primarily as an Establishment Clause case or a Free Exercise Clause case?
I would say Free Exercise Clause, since it is not allowing certain individuals to practice or to freely express their religion.
Well, let me ask you a follow-up. Who's stopping, Miss Espinoza from practicing her religion? All that's being denied is funding for school, but why can't she practice her faith as she wishes?
Well, the Free Exercise Clause of the First Amendment prevents the state from making a law prohibiting the free exercise thereof. And in that, there's an implication of equal conditions, and without access to this publicly available benefit that's available to schools regardless of their religious character, Ms. Espinoza isn't able to practice her religion in an equal manner, and therefore it's not as free.
But she can practice it, but she wants the state to pay for it. Right? Isn't that exactly what's prohibited by the Establishment Clause? She can go to church if she wants, but she wants the state to pay for her children to go to this religious school.
Well, in Trinity Lutheran, a similar problem arose in which Trinity Lutheran was denied scrap tires to be able to furnish their playground. And in that case, it was decided that although it doesn't take away from their religious mission, because it's a publicly available benefit available to schools regardless, they should be able to receive that benefit because it's not something that would hinder the state from separating their religious mission from public funding.
So you want to just, what in Trinity Lutheran, right? You had a playground, right? A playground is a place where kids play. It's not where they pray. Right? Don't you think there's a difference between a playground and a religious school?
I would say the main concern here is the scholarship program is providing equal opportunity for both religious and non-religious people to gain a benefit in order to send their children to school. It's not so much of a concern of what they practice in that school as that is parent choice of what they want their students to study. But so who gets the money and what's barring them from getting that money. And
Counselor, let me ask you a question, Counselor. Do we know how this money is actually being spent? In other words, the money being given to the Stillwater school. Do we know how the money is being spent?
No, but I think that falls in line with the third prong of the Lemon test of avoiding excessive entanglement, and I don't think that the program should be monitoring where the funds are going.
Well, but then what about Locke v. Davie, Counselor?
Well, the distinction in Locke v. Davie, what makes it different from Trinity Lutheran, or this case, is that it was decided based on the assumption that Davie's intent could be separated from his religious identity. And it wasn't denied because of who Davie was or what he believed in. It was denied because he proposed to use his scholarship money to pursue a theology degree to make himself a minister. But in this case, and in Zellman versus Simmons-Harris, the scholarship program is just being provided so that parents have the choice of sending their children to religious schools.
But short of becoming a minister, isn't there prayer going on? I mean, what happens, Counselor, if the money, in this case, is being used to purchase Bibles, right? Whatever money the state gives a school, the school goes and buys a box of Bibles. Would that be okay?
Well, what the school does with the money, I think what we said before in terms of parent choice, I think that's the most important here, because the government is not forcing children to attend religious schools. It's just allowing people to choose which type of education they want their children to receive.
Right, but again, the state has this provision in the Constitution, right? Tell me about Article 10 of the Montana Constitution. What does that article say?
Article 10 states that the legislature, counties, cities, towns, school districts, and public corporations shall not make any direct or indirect appropriation or payment from any public fund or monies or any grants or lands of other property for any sectarian purpose, or to aid any church, school, academy, seminary, college, university, or other literary or scientific institution controlled in whole or in part by any church, sect, or denomination.
Thank you. Under the Montana Constitution, the school could not get this aid, right? Are you asking us to declare Article 10 unconstitutional? In other words, is the Montana Constitution unconstitutional?
No, as existed before the issuance of Rule 1, the scholarship program was constitutional because it did not involve the religious discrimination.
No.
It's only after.
I'm asking, are you asking us to declare Article 10? Forget Rule 1 for a minute. Do you think Article 10 is unconstitutional?
I would say the application of Article 10, Section 6 is the thing that is unconstitutional.
What do you mean the application of it?
Requiring the Big Sky Scholarship Program to implement Rule 1, they would not have to do so because the Big Sky Scholarship Program itself is constitutional without it.
Let's go back. So let's go back to Trinity Lutheran for a minute, right? As I remember that case, the school was denied the scholarship solely because they were religious. Is that right? Is the religious status, that's why they were denied the money? Is that a correct reading of the case?
In Trinity, they were denied the tire scraps under that benefit program because of their religious identity, yes.
Isn't that what Article 10 does? Doesn't Article 10 say we will not give money to religious institutions because they're religious? In other words, isn't Article 10 unconstitutional on its face under Trinity Lutheran? How do you reconcile Article 10 with Trinity Lutheran? Forget Rule 1 for a minute.
Well, Article 10 prevents public funding from aiding religious institutions and their religious missions. But here the money isn't going towards the religious institution for that religious mission as much as it's going to parents to be able to make their choice to send their children to a religious institution.
Yeah, but the money's going to a religious school, whether it goes directly or to the parents. What difference does it make?
Because if the parents didn't make the choice and have that opportunity, then the money wouldn't go towards the school.
But Espinoza wants to put the money, but Miss Espinoza wants the money to go to the religious school. That's where she said she wants to give it to the Stillwater school.
Yeah, and under Zelman versus Simmons-Harris isn't a precedent that we haven't seen before. Under that program, the Ohio Scholarship Program allowed parents to have vouchers to go towards private religious schools, and that was constitutional because the key distinction was that parents were able to make a deliberate choice, and that the vouchers weren't going directly towards the religious institutions without any sort of barrier in between.
But I don't think you've answered my question yet, right? The question is this: how do you reconcile Article 10 with Trinity Lutheran? Because it seems that Article 10 says the state will not give money to religious groups because they're religious. That seems to violate Trinity Lutheran.
Well, I think that the Ohio State Constitution differs from what we're dealing with here, which is the Montana State Constitution. And in the Ohio State Constitution, it's a little bit less restrictive than that of Montana. But with that said, I still think that this is about parent choice and not so much about whether or not where the funds can be allocated.
All right, you can proceed with your arguments.
It's a violation of the Free Exercise Clause to withhold funds from religious schools, but the provision of funds withstands the strict scrutiny standard outlined in Lemon v. Kurtzman and does not violate the Establishment Clause of the First Amendment.
A case only passes the Lemon test when 1, there is a secular legislative purpose, 2, its principal or primary effect neither promotes nor inhibits religion, and 3, it does not foster excessive government entanglement with religion.
The scholarship program in question, Big Sky Scholarships, meets the first prong of the Lemon test because it was founded to provide benefits to private schools, private religious schools, and public schools, and thus making it secular in nature. It doesn't disproportionately favor religious institutions, nor does it specifically seek to serve them.
This act of providing funds to support all schools maintains an individual's freedom of choice and neither inhibits or promotes religion. In Zelman v. Simmons-Harris, the court held that supplying vouchers to low-income parents did not violate the Establishment Clause. The voucher program allowed parents to send their children to private religious, and public schools, which did not constitute support for religious education. Rather, the program was upholding a parent's ability to exercise individual and voluntary choice.
Well, but Counselor, in Zelman, wasn't the money limited to sort of secular studies? Isn't there a difference? In other words, the vouchers in Zelman couldn't go towards purchasing Bibles.
I would say that while that was the case for the vouchers supplied in Zelman v. Simmons-Harris, I think that both cases still focus on parent choice and how the significance lies in where the parents choose to send their children and not where the money is spent.
Okay. You may proceed. You have about 2 minutes left.
While the First Amendment requires the state to be neutral in its treatment of religious groups, it doesn't require the state to be their adversary. As Justice Black writes in Everson's majority opinion, state power is no more to be used as to handicap religions than it is to favor them.
The neutral intent of the budget did not propel a religious cause. The Montana Department of Revenue provides aid to all individuals in the community without considering religious status. The secular nature of the program ensures that the second prong of the Lemon test is not violated when funds are provided for religious schools.
Lastly, the provision of funds does not foster excessive government entanglement with religion. The Lemon test's third prong was first conceptually introduced in 1970 as a way to avoid unnecessary interaction between the government and religious institutions. The court explained that although some interaction between church and state will occur, It is necessary to avoid situations where the government is overly involved with religion, such as when official and continuing surveillance is required.
In this case, there is no mechanism for which the government can become excessively entangled in religious affairs. There will be no continuing surveillance after the benefits have been provided. It simply falls to parents to make an individual choice about where they want their children to attend school.
The founders' inclusion of the Establishment Clause was never meant to demonstrate
Okay,
animosity.
you have 30 seconds left, Counselor. You just wrap your conclusion.
All right. Although Thomas Jefferson advocated for building this wall of separation between church and state in his letter to Danbury Baptists, the court doesn't need to operate under this wall of separation, as stated in the majority opinion in Lynch v. Donnelly.
The concept of a wall of separation between church and state is a useful metaphor, but it is not an accurate description of practical aspects of the relationship that in fact exists. The purpose of separating church from state is to preserve religious institution from government corruption.
Okay, as Justice Rehnquist stated in the majority...
That's time. You can finish your sentence.
As Justice Rehnquist stated in the majority opinion of Zellman, the Ohio Scholarship Program is entirely neutral with respect to religion.
Okay, very good. Thank you so much. All right, I appreciate that, petitioners. Respondents, you have 15 minutes. You can begin whenever you're ready.
Can everyone hear me?
Loud and clear, Counselor. Thank you.
Perfect. All right. I'll try to make it a little more improvised than last time, just so it's not a repeat. But
it's okay.
All right. Starting time. May it please the court that I, Michael Murray, and my co-counsel Andrea Yang will be representing the respondent, the Montana Department of Revenue, in this matter. We agree to the summary of facts as presented by the petitioners and won't touch on those further. In regards to main issues, we believe the main issue here is the no aid clause and whether or not it's constitutional. Whether Article 10, Section 6 of the Montana Constitution, its no aid clause, is in fact constitutional. Now, we believe that looking at Locke v. Davie as precedent, that we can see that the no aid clause is in fact constitutional, as the court in Locke v. Davie upheld Washington State's no aid clause, saying that because there's no animus to be found either in the language, the text itself, or in the history of the no aid clause, that there was nothing to suggest animus towards religion. Thus, it was in fact constitutional and did not violate the free exercise clause. We contend that Montana's no aid clause is similar both in language and in intent and purpose to that of Washington's. And as such, we believe since the language is comparable, that there was no animus in Montana's just as there was no animus in Washington's. Secondly, looking at the history, we can see that this was included in a 1972 revision of the state constitution, so it did not originate from the Blaine era itself. But even moving beyond just the date itself, we can see that it was specifically stipulated at the time that the primary purpose of the no aid provision is the unequivocal support it provides for a strong public school system. So we can see that there was no intention to be anti-Catholic or to be anti-religious at all, but rather it was to devote as many revenue streams as possible to public education. And we also should note that this measure was supported by faith leaders of all different faiths and of all different denominations and religions. And that's because it provided a healthy, robust, distinct, and defined wall between religion and government. And that's something where it not only protects the government from becoming entangled with religion, but also protects religion from becoming entangled with the political motives and influence of the state legislature and politics in general. So it's a two-way road.
Counsel, let me ask you a question. Do you think that Trinity Lutheran represented a shift in how the court approaches religious issues? Do you think Trinity Lutheran changed things a little bit?
I think Trinity certainly changed things, but not in a way that's applicable to this case. Since in Trinity, we saw that what was being denied to churches was an obviously secular bark chips or tire chips. And so I think that I'm sure it evolved issues, but in regards to its applicability here, I think that since these funds would be funding religious instruction and religiously religious instruction just in general, that it is different from Trinity, and that a playground is not as inherently religious as obviously religious teachers or religious books or materials.
Well, but my question though is different, right? There's always this tension between the free exercise clause and the establishment clause, right? Because if you have too much of a separation of church and state, at some point you're prohibiting people from exercising their religion. And Trinity Lutheran seems to draw a line. The court says you can't discriminate against an organization because they're religious. When I look at Article 10 of your Constitution, that's exactly what I see. You cannot get any funding because you're religious. I don't know how to reconcile Article 10 with Trinity Lutheran. And maybe Trinity Lutheran changed the law. Maybe that's something new that didn't exist beforehand. But when I see Trinity Lutheran, I have a hard time reconciling that with your state constitution.
Well, I think that when we look at Locke v. Davey, it's the fact that it's not necessarily the identity of the individual, but it's what they are supposing or intending to do. In that case, it was someone who is hoping to become a theology major and thus go preach the word of their respective religion. And I think the same can be applied here to Montana, because we see that, yes, not all these folks are going to go on to be religious preachers, but we can see that the aim is still to educate and to craft, frankly, lifelong Christians in the case of Stillwater. I mean, Stillwater themselves, in their mission statement, says that they're committed to developing Christian character for life through instruction, and that they work to provide their students with a biblical worldview. And even their headmaster himself says that the Bible and religion comes into play in all aspects of their classroom setting. So I think that what we see in Locke v. Davey is a little bit different just because of the fact that it's not the identity, but the intent. And I think that what we're seeing here is the same thing, where religious education builds lifelong folks of these specific.
I get all that, but like, what do I do with that sentence in Trinity Lutheran that says you can't discriminate based on religious status? Just that one sentence. How do you reconcile that with Amendment Article 10? Because Article 10 seems to conflict, because you are saying you do not get money because you're religious. If you're an atheist, you get this money, but if you're religious, you don't. How do you square that with Trinity Lutheran? And maybe the answer is you can't. I don't know, but how do you reconcile them?
Well, I think it's like you said, Your Honor, where it is, playing in the joints between the Establishment Clause and free exercise. I mean, I think of Church of Lukumi versus the city of Hialeah, where, in that case, we agree, frankly, that it was unconstitutional to target a specific religion for no reasonable legislative purpose. But we also think it would have been equally unconstitutional if the city paid for the animal sacrifices themselves, right? So I think that those are the two ends of the extreme, where you have the violation of the free exercise clause, where the government is being oppressive and prohibiting things, but you also have the other end, where the government is supporting and perpetuating and funding, frankly, these religious activities. And I think that what the Montana Constitution allows is for it to be in the middle, where we're separating the two without imposing restrictions on these religious schools or their instruction. We're just saying that the government's not going to get into that business and isn't going to be involved at all. And so I think that it's the perfect balance between the free exercise and the Establishment Clause, because it is a very narrow gray area between the two.
But other states don't have this sort of no aid amendment. Do you think these other states are violating the Establishment Clause?
I think, 37 states have these no aid clauses, so I would
23 don't.
Yeah, well, yeah. So it's still a healthy amount that don't. I think that what we see is these no aid requirements. I think that what we see is that they help bolster the wall. I think the wall obviously exists in and of itself because it's a federal mandate and is required by the federal Constitution. But I think that what we see still is that these states have gone the extra step to clarify it and to ensure that the wall is as robust as possible.
All right. You may continue with the argument, Counselor. Thank you.
Thank you. So the petitioners at first haven't really clarified whether they would consider the Montana Constitution unconstitutional or not, and instead say it's the application. Now, we would contend that the application in and of itself, it would be in violation of the Montana Constitution, which petitioners have not stated is unconstitutional, so we'll assume that it's not, that it is constitutional. And so what we see here is the fact that these would be considered indirect payments, because these tax credits is money owed to the government that the government is preemptively forgiving or preemptively giving back to the taxpayers to use. And so we would consider that an indirect payment, which is accounted for specifically in the language of Montana's Article 10, no aid clause. Moving on is we would also look at Lemon v. Kurtzman in terms of the Lemon test, which both sides have brought up. Now, we contend that if this program were in effect, is it would violate prongs 2 and 3, which is the primary effect and entanglement. primary effect would come from the fact that we contend that this program would be indirectly funding religious instruction, that these funds would be able to pay for religious teachers, pay for religious materials, even religious symbols that could be hung in the classroom and so forth. And so we think the primary effect is that it does subsidize and advance the religious mission of sectarian schools and institutions. And as previously stated, I mean, it's no surprise that Stillwater seeks to teach people in a religious manner. That's no surprise. And they're fine to do that. Montana has no issue with that. But what we do have an issue is that the state should be on the line to foot the bill and to be able to actually pay for that or have to pay for that. And in terms of entanglement, we see the fact is that if we look at Committee for Public Education and Religious Liberty v. Nyquist, is the court struck down Chapter 414 of the New York Code, which provided in some forms tax relief measures similar to those of the Montana issue here. And they struck those down because the funds were not guaranteed to be used by sectarian schools in objectively secular ways. And that's the same thing we see here, is we don't know where these funds are going toward. They could be going to buy Bibles, for example, because these are simply tuition. These are under the label of tuition. They could be going to any expense that this school, the religious school, incurs. And so we see it without a guarantee, is we're seeing that there's this great risk of government entanglement. The government could be buying Bibles for religious schools through these tax credits. And as petitioners themselves brought up, that even if we were to develop guarantees against such funding for innate religious objects or programs, such paradigms would be considered excessive entanglement in of themselves, because the government would be acting in a regulatory and supervisory role. So we see either way the government is at risk of becoming excessively entangled, both because it is either funding these religious programs and these religious instructions, or because it is creating standards by which these churches have to follow. And so we see both ways is that it does not pass the third prong of the limit test. Now, overall, I mean, if we look at what was brought up in terms of by petitioners in regards to Everson, is we have to see that Everson is not applicable to this case here. First of all, I mean, it is a case from, I believe, 1947, so it is quite aged. But at the same time, is we have to understand that it's a different issue that was being discussed. Justice Black and the majority for Everson reasoned that the law did not pay money to parochial schools, thus it was okay. The aid went to the parents for transportation costs. No funds went to the schools or to their instructional endeavors. And that's the difference here, is that we see that unlike in Everson, where this money was covering transportation costs by the parents that were incurred by the parents, is we're seeing instead that this is money going directly to religious instruction. These are funds going directly toward the schools themselves, which is different than Everson. And I know that the petitioners brought up Everson as an example, quoting from it. We can see that it's not applicable to this situation because of the fact that the money is going to a different entity altogether than it was in Everson.
So let me ask you a question if I can, Counselor. The Supreme Court made a lot of rulings the last 60 years or so on the Establishment Clause, and it's not followed a straight line. And it seems a lot of the precedents from the 50s and the 60s and the 70s are in tension with the precedents today. Do you think a lot of those cases are still considered good law, like Everson? I mean, the court seems to just be sort of pushing those old cases to the back. I mean, how should the court today treat those older precedents?
Well, I mean, I think that you do, when it is such aged precedent, you do have to consider it with some caution. We as the respondents don't necessarily have an opinion, I'll say, in terms of whether or not the case is still relevant and is good law still to this day after so many years. But what we will obviously and vehemently maintain is that the law is not applicable to this specific case. So I think that it could theoretically be good precedent and good fodder for other cases. But at least for this one, it is for sure, it is definitely not applicable, is Montana's position.
You have about 2 minutes left. You can wrap up your argument, Counselor.
Yes. All right. I mean, overall, if we look at it, we maintain that that the no aid clause is in fact constitutional. I don't know how much that is disputed by the petitioners themselves, but either way, we'll say that if we look to Locke v. Davey, that the standard provided by the court in that case was whether there was animus in the history of the text. And we believe that because the text is so similar between Montana and Washington's no aid clause, then it follows that if Washington's text had no animus, then Montana's doesn't either. And again, of course, as we can look at the history itself, see that it historically was implemented for a legislative purpose, not for religious animus or anything of that sort. And one thing I will end on for some novelty is going back to this idea. This no aid clause was supported by religious leaders at the time, faith leaders, and that's because we have to understand that this no aid clause protects both sides, in the sense that both sides are protected. Obviously, in the case of still waters, the parents want the money and say that they need it. But we have to understand that more broadly, this protects the sanctity of religion. It makes sure it isn't contaminated by quote unquote worldly motives, as St. George Tucker put it, and that it doesn't mix in political influence and political maneuvering with this with religion out of itself. And so it keeps a healthy separation between the two. And then obviously in regards to the Lemon test, we see the primary effect would be to fund religious instruction, as is just plainly the facts of the case. And of course, this entanglement, because we see no guarantees. And so we see that this funding could be going toward buying indisputably religious items. And so for these reasons, we hope the court finds for the respondents.
Perfect timing, right on schedule. And I didn't ask him any questions. We grilled him before. I didn't want to kill him quite as much. So it's mostly for the benefit of the petitioners that Michael and Andrea give it another go. So I gave him a little bit of an easier pass.
All right. Running out of things to say at a certain point.
I know. I don't want to give you too out of a time. All right, petitioners, Dalia and Sera, you can begin whenever you're ready for rebuttal. You have 5 minutes.
The respondents argue that the precedent of Locke is more applicable here, but there is a key distinction between the two cases. Washington's promised scholarship was constitutional in its exclusion of devotional theology majors because the state was not excluding someone for their religious character. They were excluding because of what Davy intended to do, use the funds to become a minister.
Proceed.
Dalia is...
Oh, I'm sorry, Dalia, you're on mute.
Am I back?
You're back.
Yes.
I can hear you.
And this is something we agree with the respondents on, is that in Locke v. Davy was, what he proposed to do was unconstitutional because it wasn't his identity that caused the problem. But here it is the identity of the church, and it's the religious mission, similar to what was in Trinity. It's because they are religious that they're discriminated against. And Chief Justice Roberts even distinguished in the majority opinion in Locke v. Davy that there's no question here that Trinity Lutheran was denied a grant simply because of what it is, a church. It's not that Trinity was proposing to use this grant for other purposes. It's just that they were a church, that they were immediately stopped from receiving this money.
So similarly, in this case, the schools are being discriminated against because of what they are and what they're affiliated with.
But counsel, let me intervene. I think I agree with you on that much, right? That the state constitution is denying aid because of religious status. But in this case in particular, how is your school Stillwater different than the situation in Locke v. Davy? Isn't this just funding religious instruction? I mean, isn't that prohibited regardless of what? I mean, in other words, even if you win on the Blaine Amendment, the no aid provision, don't you still lose because you have a religious school that's doing religious instructions?
Well, Your Honor, we look at cases like Zellman and say that the key fact here is that we have this parent choice and that we're not just taking public funds directly out of the state's pockets and then just giving them to these religious schools. This program was established as a secular program to provide aid not just for the religious schools, but also other private secular schools. The key distinction is that the parents can choose to pick where their students attend, and they don't have to go to the religious schools. The state isn't saying that they should. They're just providing the option to do so if they want to.
Okay. And let me ask one more question. Can you find any sources in the founding era what the framers may have understood this issue? What light does their view shed on this question?
to reference what the respondents referenced, they referred to this wall of separation that we found evident, especially in Thomas Jefferson's letter to Danbury Baptists. And we would actually say that this wall is no longer an applicable standard to look at cases involving the Establishment Clause. Rather, we turn to the endorsement standard and say that because there really is no endorsement here of government involvement with religion, the government isn't giving these religious schools money.
Hold on. Why do you think the wall analogy is no longer relevant? Has the Supreme Court said we don't have a wall anymore? Is that no wall? What happened to the wall?
Since Lynch v. Donnelly, the court has changed a little bit the way they look at Establishment Clause cases, and it's pretty evident that there is going to be some involvement between church and state, and that this wall metaphorically is a good sentiment for keeping government activity separate from religious instruction, and as our respondents mentioned, to protect both sides basically. But in cases like this, without voiding that wall of separation analogy, religious institutions will be disadvantaged simply because they are religious.
Okay, you have about a minute left, Council. You can wrap up.
We would like to say that there is no legal grounds in which the Montana Department of Revenue can deny religious schools a generally available government benefit simply for being religious. Such an act would undermine the preservation of choice and free religious exercise fundamental to the First Amendment.
And once again, we'd like to reemphasize the similarity between this case and the case in Zellman, which is parental choice. As Justice Rehnquist writes in Zellman's majority opinion, the voucher program confers educational assistance directly to a broad class of individuals defined without reference to religion and permits participations of all school districts, religious or non-religious, in adjacent public schools.
Okay.
The only preference in the program
and that's time, Counselor. You can finish your sentence.
The only preference in the program is for low-income families who receive greater assistance and have priority for admission.
Okay, thank you so much. I'm going to waive the rebuttal for the other team because I think they already argued enough, so I'll let you guys off the hook for one more round, but I'm grateful that you're able to volunteer to give your classmates a reasonable experience. Let me say I'm proud of you all. These are not easy questions. I ask very hard questions quite deliberately. Because I want to see how well you're prepared, and you responded very agile, very, very flexible. I would always try and make you draw a line, and as soon as you draw the line, try and push you over the line. If you see what I'm trying to do, say, well, if you accept this position, what about this? And what about this? Oh man, you're toast by the third one, right? But you did well. You resisted my hypos as best as you could. I think you gave ground where you had to, but you did very well. I see Mr. Kepping has joined. Your kids did very well, Garrett. I'm very, very proud of all of them. We had 3 excellent rounds, so kudos to them.
No, I look forward to watching the YouTube videos. And
just
thanks for arguing twice. Appreciate that.
Just one note, Garrett. Your student in your second class asked not to put it online, so I won't.
Oh, okay.
But the other ones will be online. Sebastian, is there anything?
Could you send it to me?
I can do that. Yes, I can do that.
Yeah, thanks.
Yeah, Sebastian, is there anything you'd like to add?
No, this is a great round. I've really enjoyed it, and thanks again to the respondents for going twice.
You know what I can do? I can put it on YouTube in a private mode, so only you can see it. That might be one way of doing it.
Perfect, thank you.
Okay, because there's no good way of sending an 8 gigabyte file. It'll take forever to download.
Oh, probably not.
Yeah. Okay. All right. Are there any questions from the students? From Dalia, or Michael, or Sera, or Andrea, any questions from you? Well, thank you all very much. I'm grateful. Sebastian and I will confer a little bit later on the gradings, but hopefully we'll have something for you maybe by next week or so. Thank you all so much. Have a wonderful evening.
Thanks.
Thank you.